Hi everybody, I'm Vic Khurana, a partner in the Tech Transactions group at Bristow's. I'm just going to intro how we're going to run this last session of the afternoon on contracting for AI. So I feel like during the course of the afternoon we've had some proper IP law and regulatory law and insights. I think we're going to take it back to what every tech lawyer's first love and enduring love really is, which is contracts, right? Okay, I'm glad I didn't do a Slido for that. But anyway, we're going to talk about contracts, especially, well, solely AI contracts, as they form more and more part of our daily work. And we're going to run it in two parts. So first of all, my colleague Elisa and we're going to present some benchmarking analysis of 10 of the large GenAI providers' latest terms of service to see where they are at with those. And then in the second part, my colleague Anneke and I will cover how to think about contracting, or starting to think about contracting for compliance with the new EU AI Act. So a few minutes along, thank you, Elisa. We're going to just set the scene for this benchmarking market practice session on GenAI. So as I say, we benchmarked the latest terms of service of 10 of the biggest GenAI providers in the market. And we think it's a good time to do this update because it's been a couple of years now since ChatGPT and certainly the enterprise versions of GenAI services were launched. And there's been some movement in the market in that time as those providers have started to address the concerns of enterprise customers. And those enterprise customers themselves have now pretty much across the board embedded their own AI policies or their own approach to risk management of the use of these tools. So what we presented today is not necessarily to sort of try and teach you how to negotiate these terms, because quite often that's not going to be possible. But we do think that some of the trends we'll talk through might make people rethink a little bit of their risk appetite about how they think about accepting the risks of some of these terms. And actually, in fact, some of the use cases that might think that they can use for these tools based on where we're at in the market now. So I'll hand over to Elisa to talk through the first set of issues.
So hi, everyone. The first provision we looked at as part of our benchmarking exercise was ownership in outputs. And here we encounter the problem that Toby talked about in the very first talk on copyright and AI, which is that we just don't know if IP exists in outputs, and if it does exist, who owns it? So how do you deal with that in terms of service? All 10 providers allow the customer to own the outputs, but they do this in a slightly non-committal way. So they tend to phrase it as provider does not claim ownership, or customer retains all rights. And most clauses also contain caveats, so to the extent permitted by applicable laws. And only 2 of the 10 terms that we looked at include an express IP assignment from the provider to the customer in case the provider ends up being the first owner of the outputs. And they draft the terms this way precisely because of this uncertainty in ownership of outputs. And they don't want to somehow guarantee that there will be IP in the outputs and that the customer will own this. So where does this leave customers? Depending on the use cases, might be absolutely fine. So either the customer owns the outputs, or if the customer doesn't, then no one does. So using the output wouldn't infringe any third-party rights. But if an output is particularly valuable, then this is a risk, as the customer may not be able to enforce its rights against third parties. It's also worth noting that one of the providers we looked at required customers to subscribe to the highest tier subscription for this to apply, so it's definitely worth checking that. So staying on the topic of using outputs, let's move on to accuracy and hallucinations. And hallucinations is the AI version of if you say it with enough confidence, they'll believe you. So there have been a lot of high-profile examples of where this has gone wrong, some of them very funny, some of them very concerning. All providers we surveyed take this into account by warning customers.
Just messed up my mic. Carry on.
By warning customers of this in their terms, by saying that they might not be accurate and that customers shouldn't rely on them. So we've put some of the wording up on the screen. A common one is use discretion before relying on generated content. In addition to this, 7 of the 10 providers expressly exclude all warranties as to accuracy, and the other 3 achieve the same by just generally excluding warranties. The risk is therefore all on customers to manage. And this can be done by educating employees and also implementing compliance controls to ensure that any information that the business relies on is independently verified. So for example, you can ask the services to cite their sources. This could help with the verification exercise. And there are also more technical mitigations. So for example, further fine-tuning or implementing retrieval augmented generation, or RAG, which allows customers to control the knowledge base from which information is retrieved. So next, moving on really quickly from outputs to inputs. First of all, there's no question the customer owns the inputs. And in fact, 8 out of the 10 providers require customers to warrant that they have the necessary rights to provide the outputs. But providers often require rights in inputs and also in outputs that go far beyond what is necessary to provide the services. 8 out of the 10 providers we looked at require rights to use customer data to improve services and to develop services. So this could include using customer inputs and outputs to train AI models. But 3 of the providers actually go much further than this, and they require a right to use customer inputs and outputs for any purpose whatsoever. These rights are perpetual and they're irrevocable. This could have severe implications if employees are not careful about what information they provide. So for example, if they provide confidential information or trade secrets, the information could lose its protected status. One mitigation could be to pay for the service to opt out of this use right, but actually only 2 of the providers we looked at offers that option. So in practical terms, customers are left managing this risk by implementing AI acceptable use policies and educating employees as to the risks.
Thanks very much, Elisa. So I'm going to move us back. I'm going to move us on to indemnities and kind of back to some of the, I guess, the flip side of the IP issues that Toby Hedden was talking about in the first session. We looked at what kinds of commitments around IP protection the big providers are giving these days. And we looked at 2 types of indemnity. So the first one around model usage. So as a customer, your use of the model itself, the risk there, I guess we're talking about, is a claim made by a third-party copyright holder who thinks their data was used in training, and by using the model that you've used some of their training. So Toby talked about the infringement cases on foot about that. 4 out of 10 of the providers are giving indemnity protection for that. And I kind of think that reflects that it's maybe a slightly less relevant risk for a customer, partly because those claims at the moment are being made against the model providers. I think the more interesting area here is the outputs, often being called copyright commitments or copyright shields, where 5 out of 10, so half of the big 10 vendors are giving those. And there's been a bit of a question mark about how they apply and some of the enforceability of those, because there were some quite splashy announcements in the last year or so around those copyright commitments. And sometimes they were announced online or with statements and not necessarily reflected in the terms of service. So we kind of looked at those. On the whole, we think they're intended to, and they probably are, binding addenda to the terms, except to say that in some cases now they've moved beyond simply publishing press releases and statements and clauses online and actually amending product level T's and C's, which sort of sometimes sit under the general terms of service. So, and here there's a bit of risk we find. When we've looked at this before, some customers have thought they were covered under the amended wording in some of the product level T's and C's, but actually they weren't on that product. So some of the definitions around what a covered product is, it's worth checking those out. I think the relatively safe rule of thumb is that if you're paying for an enterprise-grade GenAI service and that vendor has made a copyright commitment generally, the chances are you're covered by those. But there's a lot of limitations and conditions around the commitments that they're giving. On the right side of the slide, just kind of showed an example of some of the vendors and the caps, liability caps that applying to those indemnities. They don't tend to be unlimited. In 3 out of 4 cases for model usage, they were capped at 12 months fees, in one case capped at a lowly 10,000 euros, which is quite a different market position to the wider SaaS market, I think, when it comes to customer IP protection largely. And that reflects some of the nervousness about the IP issues that Toby was talking about earlier. And just to say also, there's a raft of more specific GenAI conditions and exemptions that the vendors are applying to some of the commitments they're giving. So on the left side, some of the typical conditions I sort of mentioned, you've kind of got to be on a paid for enterprise subscription tier, the free, or 20, 30 user services are maybe not covered by those commitments. You've got to implement some of the mitigations that the providers are suggesting you do or requiring you to do to benefit from them. So in some cases, there are things like you've got to apply meta prompts. So you've got to say something like apply a meta prompt if that filter was available. That basically says something like it caveats every prompt you ever do by saying make sure you don't infringe copyright law. So if you don't do that, then they're not necessarily, some vendors in some cases, they're not giving you the benefit of the commitment. For some of the code generation tools, they're saying, look, you've still got to comply with the license terms and some of the open source terms that apply to some of the generated code. So they're applying some Creative Commons and open source licenses to the generated code. So you still got to look at those, and those do affect the level of copyright commitment they're giving there. Conduct of claims, kind of obvious that they're all wanting you to give them conduct of claims given how much is at stake for them in the big cases. They don't want individual customers defending those issues themselves. They want a centralized view and deal with them. Modifications and fine tuning. If you do that to the model, say you have an API license or an ability, or you've installed it on-prem to configure it, that can just automatically obviate the commitment that they give in some cases. Sometimes it's a bit more nuanced. Sometimes they say, well, if you do that, it applies an extra layer of requirements on you to test and evaluate outputs yourself for non-infringement before you then benefit from those commitments. That's kind of unclear where the responsibility lies there. And actual knowledge, if you're producing some output and you know or should have known or kind of know it might infringe someone's IP, then they're not covering you for that. The little word cloud there, I won't run through them all, but just kind of putting out some interesting points. So on inputs, vendors are saying if you didn't have the right to use the inputs in the way that Elisa was describing earlier in breach of those warranties, then if you generate an infringing output with that input, they're not giving you the protection there. Trademarks and branding, if you're using generative AI services to create those, unless it's from one of those vendors like Adobe or someone who is expanding the commitments they're giving here, they're expecting you to do your own brand clearance. They're not going to cover you for trademark infringement if you haven't done the brand clearance. And it's it's important to remember that on the face of it, we're seeing these commitments, but they're not unconditional. There's a lot of technical features to apply, settings to apply, and some use cases which are just not covered. So it's important, I think, to bear that in mind in sort of the use cases that come across your desk. And I think we'll probably cover this in the takeaways a little bit, where there is movement in the market here. Some of these stats would have been less favorable to customers a year and a half ago. But I think what that means is some of those blanket restrictions on don't use GenAI for broad sets of use cases, we can be a bit more nuanced now to say, okay, well, you could potentially use it for this, but make sure you've got the input rights and double check that, because otherwise we won't get the commitment. Or you can say to project teams, look, use it for generating outputs, fine, in your workflows, but bear in mind, if you embed this LLM in a wider product, well, we won't get the copyright commitment. So there's a bit of differentiation in the market here going on. So flip side of this, customer indemnities, what are vendors asking for from customers? And yeah, it's quite a reverse position in a way. Almost all of them are asking for indemnities in relation to how you interact and use the model, the inputs you put in, and your use of outputs. So if they're receiving third-party claims from third parties, and they're because of your use and behavior in using the tools, they're asking for significant indemnities, tend to be uncapped, not probably untypical in the wider standard software as a service market, except for the lack of reciprocity. And probably what it really means is it just places more emphasis on internal policies and guardrails around making sure you've got right to use inputs and careful use of outputs, which I'll come to next as well. So last issue we looked at was compliance with applicable law. Yeah, didn't really need the graph, right? Just could have just done one. So yeah, none of the providers are committing to do that. I mean, in defense of that, I'm not necessarily saying it's a reasonable position, but it's kind of consistent with Elisa's point earlier about the accuracy and hallucination risk. That the position in the market of the standard tools and services is that you're not really meant to rely on the output as it exists at that point. So if you choose to then use it in a regulated setting, then the risk is kind of on customers. It's kind of consistent with that. And to be fair, also consistent with the kind of internal policies, acceptable use policies we see customer clients apply anyway, which puts guardrails on the use and reliance on the accuracy of those tools too. It's probably also consistent with the wider legal position until the EU AI Act, nice segue for what we're going to talk about next, where so far there hasn't just been a clear, beyond GDPR, specific regulation sort of covering the provision of these GenAI services. So they could probably argue, well, there's no applicable law until August 2024 anyway. And contrast that with the flip side, 9 out of 10 cases, customers are asked to give that corresponding commitment. And again, it's more of the same, really. I think they're just saying, look, if you choose to use this in a regulated context, it's kind of up to you. It's a general purpose tool.
So before we start to finally talk about the AI Act, let's just summarize what we've just discussed. So there is a lot of uncertainty regarding outputs. So we have to assume that customers may not be able to enforce their rights against third parties and that they can't rely on outputs. And there's a range of rights that providers have in inputs and outputs and a range of protections that they provide. And this makes it even more important for lawyers advising on these terms to really understand the proposed use case from the business. So for example, if the proposed use case is brand asset creation, then certainty on IP will be really, really important, but maybe the service provider's use of inputs is less important. Contrast this with the text-to-text model that your teams use in their everyday work to generate summaries of meetings. Here, there is less of a need to own the outputs, but there is a huge concern as to the provider's use of confidential information. And a lot of this can be documented in acceptable use policies, which I'm sure many of you have implemented in your organizations. But documenting is not always enough. So double check that it remains relevant with the commitments given by the providers in their terms or the lack thereof. And also find ways to educate employees of how this could actually materialize in practice.
Thanks, Elisa. I would just add to that as a final word to say, I think, as I sort of alluded to, those graphs are more customer favorable now than they were 18 months ago. And I think where we are, if you've got a policy or a risk management framework governing this that's a couple of years old or a year and a half old, it might be a good idea to rethink and revisit it. Because there's got a lot of differentiation now between the vendors and even the type of mode, what the tool's generating. So for image generation tools, there's probably we didn't go into this granular detail, but there's lesser commitments on the IP side, probably because there's more nervousness about images than there are about text that people just use in their direct work, and there's less reliance on the IP. So I would sort of say to people, if there's think about it from a use case perspective, in the sense that it could be okay for certain use cases, and some of the conditional approvals we see to teams approving them is based on a use case at a point in time, factoring in what the vendors are saying and the protections they're offering, as well as wider AI governance and risk management factors. All right, so we're going to move on to the second part and the last session of the afternoon. So contracting under the AI Act. So we're going to assume for the purpose of this session, Anneke and I, that people have a broad familiarity, at least conceptually, with the AI Act itself, partly because a lot of the focus in the run-up to it becoming enforced in August and beyond has been about compliance, in the sense that people are trying to work out whether and how it applies to them. Are they using high-risk systems, deploying them, providing them, and then how they think about compliance? I think we also think it's going to have a significant impact on contracts. And here I think there is a parallel with something like GDPR, which came out and said, look, there's direct duties on different elements of a supply chain in relation to technology services. And unlike GDPR, which has got handy Article 28, which kind of gives you a checklist to think about embedding in contracts, the AI Act does not have that. So we're trying to do a bit of an approximation of that today, but quite high level, and based on a particular fact pattern, because there's such a wide ecosystem in AI the Act applies to, we've picked a fact pattern that Anneke is going to cover. And just one word and one framing point to go into this. Whatever you say in the contract ultimately is not kind of obvious, but not determinative or conclusive of how the act is ultimately going to be applied to you. You could decide the basis of the assessment of whether it's high risk or not and who the roles are, but nothing to stop a regulator coming in and saying and disagreeing with that. But we do think the contractual exercise can force the parties to the deal to think about how compliance works for them, agree the basis on which they think they've assessed the tools and the roles and responsibilities, and give them a good, it's probably a good argument to show and a good demonstration that they thought it through. So over to Anneke.
Yeah, so today Vic and I want to put the Act into a bit of real world context for you and look at two scenarios that are both potentially high risk AI systems under the Act. So the first one is a HR system that uses AI to analyze which employee should be promoted to senior management. And the second is a machine learning algorithm that is used to assist in medical diagnosis, such as detecting early signs of rare diseases with from medical images.
The HR one's not an internal tool, just to be clear.
Yeah. So these are examples of work that Vic and I have advised on, and we're going to use them to break down some of the key concepts in the Act. And what we want you to have in mind is to think about what the parties might want to address in their contracts. So we appreciate that the Act is quite a lengthy and detailed document. So we recommend there's a meeting of minds on some of the framing issues when you kick off a project. So it might sound obvious, but the first step is to clarify whether you think the AI solution is or isn't an AI system subject to the Act. Usually the provider is better placed to make this assessment. If you're the deployer, you might want the provider to demonstrate their rationale or disclose their assessment. But beware, even if you agree in the contract that the Act does not apply, that won't stop a regulator from treating it as such. And this could have regulatory implications for the parties. You might want to make provisions for what would happen in this situation. For example, who deals with the regulator, what provisions apply. Also, even if the Act does not apply, that's a point-in-time decision based on current specifications and information from the provider. You might want to include in the contract the specifications and information that you use to make that decision. Because, as Vic raised, things develop pretty quickly in the world of AI at the moment, and that assessment might not apply to later versions of the AI solution, which could possibly be caught by the Act. The second thing is that the Act refers to a lot of roles in the AI supply chain: provider, developer, distributor, importer, supplier. But the two key terms to focus on are provider and deployer, because there's obligations under the Act on both of these. So generally, we think about a customer as a provider and a supplier as a provider and a customer as a deployer. We recommend in the contract that regardless, you allocate the roles to each party so it's clear.
Yeah, I mean, on that point about roles, the real world examples we're seeing here are actually not so straightforward sometimes. So using some of our examples, think about if that medical device company, that deployer purchasing an algorithm, if they're embedding that within a wider product and putting that on the market, the Act will say that they're the provider of that AI system rather than the original provider. So all of the duties will fall upon them. And so what does that kind of mean? That kind of means everything we talked about and all the product safety aspects that Will covered on CRA that apply broadly applicably to AI Act, they're going to have to do that as a market authorization to get their product on the market. And it probably then also means that that system is out of the hands of the original provider. And I think where the rubber hits the road in the contract is that that might be the basis of the deal. But think about the impact if someone didn't end up doing that. That medical device company decided, look, we're just going to use it internally. We're not going to provide it on the market. You're kind of in breach of the framing of the contract.
Yeah.
That might mean that kind of reverses the burden back potentially to the original provider who might not have understood that and actually the clauses just wouldn't be right for that, and actually there's a potential breach of law going on there. So I think the key here is to identify this complexity between the roles, because in the real world there's a lot of embedding, there's a lot of product onward provision of these products and services imagined, and so dealing with that complexity up front in the kind of what we're calling framing provisions we think makes sense.
Yeah, I completely agree. So next up we have the territorial scope of the Act, which is similar to the GDPR. The Act has extraterritorial scope. But if the provider does not intend to place a system in EU markets or for the outputs to be used in the EU, the Act might not bite. In this situation, the provider might want contractual commitments from the deployer that it won't use the AI solution or outputs in the EU. But you can only do this if the deployer is not EU-based, which means that the provider must do know your client checks, confirm the intended use with the deployer, and for global deals, bind the deployer's affiliates to non-use in the EU. So we have some good news. There are exceptions to the Act, but it's unlikely that they'll apply to you. So we've got national security and research and development exceptions that apply only if the AI solution is used for these limited purposes. If you want to take advantage of these exceptions, you probably want to record this in the contract and include warranties and commitments limiting use to the scope of the exceptions. It's similar for free and open source software, but it's a pretty narrow exception. Plus, to be honest, we think that OSS developers will use a standard OSS license anyway, so it's unlikely that you'll negotiate something bespoke here.
Thanks, Anneke. Last point in framing, change management. So Annike's alluded to it, but all the kind of careful framing we're trying to do here in the fact pattern is based on quite a carefully calibrated set of systems and roles and relationships, and then the consequential provisions you might build around those. But as Anneke mentioned before, that's kind of based on the point in time solution. And as we know, it's moving on very, very quickly, and change and new releases and updates are pretty much baked into the AI lifecycle like any other technology product segment. And so think about what a significant change could do to that status under the Act that you determined. And so I think we might need to think about this a little bit differently to normal SaaS, because I think you need a control for this, both sides. So normally we, practicing for a customer, we typically say, look, we want as many of the updates, upgrades, new releases as you can handle for us for normal money. But actually, if that's the case, and that could alter the system and put it, say, tip it into high risk system or use, we might need to control for that and say to the provider, well, look, we need to deal with this a bit more through change control with a clear impact on what it means for the status, our status of our deal under the Act. I think similarly, if you are a provider, you'd be a little bit concerned about a deployer using your system for uses that were not intended on the day one signature of the contract. So, because as we know, high risk is, we'll come on to high risk in a second, but defined two ways, right? At the system level, Annex 1, and the use level, Annex 3. And so if you're agreeing that, look, it may not be high risk right now, but suddenly we, customer, decide to use it for loads of high risk purposes, there is a chance that we as the customer are not compliant, and we won't be able to back that off against our provider supplier. And it could even mean the provider system could end up itself being deemed to be a high-risk system when they had not intended that or even acknowledged that. So I think there's something that hasn't been talked about that much that we're starting to advise on, which is even if you don't have a high-risk AI system, it's not, you've determined in your own compliance it's not high risk, I think we need to bake in provisions on customers to make sure it doesn't tip you into that aspect of the Act. So we're going to move on to what we're calling use provisions, which sort of govern the ongoing use of the tools after having framed the relationship. So high risk, kind of alluded to it, different ways that the Act defines high risk. I think in terms of the contract, it could be as simple if everyone agrees that the provider's providing a high risk system, that they'll have complied with the Act. And it probably makes sense to record, and this is where the customers have dependencies on the supplier, to record why it's high risk. Is it just one of the systems in Annex 1? Or is it because it's provided on the market for one of the uses in Annex 3? And it makes sense to then record that in a contract for the benefit of both parties, really. Because if you're a customer, you probably want the provider to commit that the system will act in the way it needs to, even if it's high risk. And if you're the provider, you probably want the customer to commit that will only use it for those intended purposes and not more broadly. It gets more challenging if you're using an AI system that the provider has not marketed and not got market authorization for as a high-risk system, because there, as a customer, you could end up tipping them into that high-risk scenario, as I sort of referred to. So I think agreeing the basis of why or why it's not high risk and looking at the act to then pull out from that to document why, which aspect of those annexes and uses it is, makes a lot of sense. And it's related to this other aspect of other point about intended purpose. So as a provider of a high-risk system, there will be a scope of market authorization that you put it on the market for certain purposes. That's all you're permitted to allow it to be used for. That's your duty under the Act. How you comply with that duty? Well, you probably need to put some controls, restrictions, or scopes of permission that your customer can only use it for those intended purposes and no others, because otherwise it could put you as a provider in breach of your own duties. Thank you. A few more kind of use provisions, and these all derive from principles in the Act. So providers under the Act have a duty to implement a risk management system. Part of that is to try and prevent misuse of their systems and enable their users to use them safely. As part of that, they are required to write and publish some instructions for use, which provide information about how users can use it safely. Kind of makes sense that given they've got that primary duty, to then flow that through to customers to say, look, you've got to comply with the instructions for use in your use of it, because we're both managing the risk that way. And equally, if you're the customer, you're then thinking, okay, well, my provider is directly regulated about preventing misuse. They could receive regulatory fines or other action if I don't do this. Conversely, you might think, well, I want to make sure my use is safe. So if I comply with the instructions for use, I kind of want to know I'm not going to be liable to that provider if misuse arises, or at least to say, if I comply with the instructions for use, and because of that, some incident arises, then I'm not liable. So there's a risk allocation point here, which is nowhere near settled in the market, but it's just a point to sort of surface, I think. Incident management, kind of after a provider's got that market authorization and their system is on the market, they are required to do post-market surveillance. One of the requirements there is to identify and report serious incidents, kind of broadly defined, it's not really more unpacked than that, to regulators. Now, they're going to have a strong dependency here on customers, because some of the incidents we suspect will only surface from a customer's use of it. So how does that play out in the contract impact? You probably need to put obligations on your customer to notify you of serious incidents that arise, to cooperate with you, and maybe even in the context of regulatory investigations, and also allow you to conduct the kind of corrective action that you have a duty under the Act to do as well, which Anneke will touch on. And there's a kind of a risk allocation point here again, because I suspect what we might see is some providers trying to risk transfer this to say, look, if there is a serious incident and it's in relation to it happened on your watch, Mr. Customer, that we're going to say, if we get a regulatory action, we're going to try and play that through. I think there's going to be a risk allocation discussion around this bit in the back end of that incident management discussion too. So we'll round this off by doing Annike's going to do a bit of a wash up on other kind of, not random at all, but slightly random other high-risk AI Act requirements on both providers and deployers. And people who have been working in and around the Act so far will be familiar with the core requirements on the left-hand side. We think that a lot of the compliance work for providers will be done around those things at the design, development, product launch stage, but there are going to be ongoing obligations and duties on both parties there, either because the provider is dependent on the deployer for it to comply, or the deployer might want some assurances from its provider that it's done the things it needed to do as a high-risk system provider.
Yeah, cool. So let's do a whip through this list. First up, we have data and data governance. Under the Act, the provider must use high-quality data sets for training, validation, and training of the AI solution. The impact on the contract is that deployers might want language about the nature and provenance of the data sets. But also beware, if the AI solution is processing personal data, a DPA may also be required. Next up, we have transparency. Under the Act, the key requirements are on the provider, and they must design and develop the AI solution in a transparent manner so that the deployer can interpret and use the outputs. For example, unless it is obvious, it should be clear to a user that they are interacting with an AI solution and not a natural human, or the outputs are marked as artificially generated or manipulated. In the contract, the deployer might want a right to the provider's transparency information so that way it can meet its own compliance obligations under the Act. There's an obligation on both providers and deployers to have human oversight of the AI solution, particularly for decisions. So how do we fulfill this in the contract? The provider should give contractual commitments that the AI solution has been designed and developed with human inference data and that the system's decision-making process can have humans in the loop. In turn, the provider might want a contractual commitment from the deployer that it does have a process in place and there will be humans in the loop for decisions. For accuracy, robustness, and cybersecurity, this is a space to watch. At the moment, there's not really any best practice around this. The European Commission has indicated that they will be working with stakeholders to develop more detailed requirements around accuracy and robustness, including developing benchmarks and standardized methodologies. As those standards and best practices develop, we're expecting to see contractual language requiring companies to comply with these. In the meantime, we're waiting for developments, so this is one to keep on your radar. Under the Act, if the provider learns or has reason to believe the AI solution does not fully conform with anything in the Act, they must take corrective actions. The provider can do this by bringing the system into conformity, withdrawing it, disabling it, or recalling the system. In the contract, the provider will need to have these rights to suspend, withdraw, or recall the system so they can comply with their duties under the Act. And if you're the deployer, you might want remedies if the provider has suspended or withdrawn your access to the AI solution. Finally, is FRIA, a Fundamental Rights Impact Assessment. Think of it like a DPIA. A deployer of high-risk AI systems, like our examples at the start of this presentation, will have to do a Fundamental Rights Impact Assessment. This assessment deals with EU principles such as human dignity or non-discrimination. If the deployer is doing an FRIA, they may need information from the provider. We anticipate that in time, the provider might even have a template FRIA, similar to what large tech providers have for DPIAs. Look, it is worth noting that the FRIA is not something to agree to in the contract, but it might need to be done prior to contracting. Back to you, Vic.
Thanks very much. So just some key takeaways. So I think up front, I think we want people to be assessing whether the Act actually applies to them and how, and then recording that how. I think in this fact pattern, it's been about high-risk systems and uses, but as we've alluded to, there's a ton of other types of relationships here that you could document and agree. I think those roles of responsibilities are key, and then controlling for change, I think is going to be quite key to not tip people into different parts of the Act that they didn't intend to be in. And then a bit like some of the other legal frameworks we talked about, the law is creating dependencies on each other in terms of parties here, so they're going to be flowed through, and I think we've run through those. And then, don't forget risk allocation and liability, because I think some of what we're talking about is not net new in terms of, well, if you suspend a tool, what do we do? But it's deriving from legislation, and so if someone's complying with applicable law, then they may infer that they've got these rights or justify they've got these rights. But as customer deployers, I think we think about the downstream negative impact on them. So thank you very much.
Yeah.